Thank you for being here today. My name is Jonathan Sines, and I'm the president and attorney for Texas Values. I'm honored today to be joined by State Representative Jodie Laubenberg, the author of House Bill 2, and so many strong Texas women and leaders from across the state of Texas. House Bill 2, which is being challenged at the U.S. Supreme Court, was passed in 2013 by a bipartisan group of legislators here in the state of Texas. This law is going to be argued on March 2nd at the U.S. Supreme Court. March 2nd just happens to be Texas Independence Day. It's going to be a very important day for the state of Texas, but also a very important day for Texas women and children across the state and across the country. Because House Bill 2 ensures that there are common sense health and safety standards that women and children deserve. These are basic human rights that should be upheld and protected in our law. Texas Values has submitted a brief before the U.S. Supreme Court on this issue on behalf of Texas Values and also on behalf of 3801 Lancaster Film Project, which is an award-winning documentary film that talks about the issue of Kermit Gosnell, an abortion doctor who's now in prison, an abortion doctor who did some unspeakable things to women and children that likely would not have happened if laws like HB 2 would have been in place and had been enforced. We will talk a little bit more about that, and you'll hear more from folks here about those issues. The amicus brief by Texas Values states in part that the Kermit Gosnell grand jury report specifically recommended that states require all abortions to be performed in ambulatory surgical centers. The abortion clinics should be explicitly regulated as ambulatory surgical facilities so that they are inspected annually and held to the same standards as all other patient procedures. The grand jury in the Kermit Gosnell abortion case also found that the abhorrent conditions in Kermit Gosnell's facilities and practices inside his abortion clinic are directly attributable to the Pennsylvania Health Department's refusal to treat abortion clinics as ambulatory surgical facilities. These and other findings in the grand jury report provide ample support and a need for House Bill 2. In fact, the reason that House Bill 2 was enacted was in response to the unspeakable things that abortion doctor Kermit Gosnell was doing in his abortion clinic that were going unregulated and unchecked. And you'll hear a bit more about that in a minute. But I am honored to introduce today and have a part of our press conference the author of House Bill 2, State Representative Jodie Laubenberg.
Well, good morning, and thank you for coming and taking a little break off the presidential campaign. So I am here not only as the author, but as also one of the names signed on to the legislative amicus brief being filed with the Supreme Court. But like many Americans, I was horrified by the abuses uncovered in the Kermit Gosnell case. Gosnell was an abortion doctor who killed babies and endangered women. He's currently serving 3 life sentences for killing an abortion patient and 3 babies who were born alive at his Philadelphia clinic. The grand jury that indicted Gosnell in 2011 called on state legislators across the country to find the fortitude to enact and enforce necessary regulations to ensure this kind of thing won't happen again. The grand jury specifically said that abortion clinics should be regulated as ambulatory surgical centers, and that we should hold abortion clinics to the same standards as other outpatient procedure centers. So we went to work, we joined other states in adding common sense measures to protect Texas women. House Bill 2, which we passed in 2013, was explicitly created to provide Texas women with the highest standard of health care. That includes holding abortion facilities to the minimum standards for ambulatory surgical centers, and that abortion doctors must have active admitting privileges at a local hospital. For reasons that are clear, when something goes wrong with an abortion, the patient can receive critical care as quickly as possible. It just makes sense. Statistics suggest that 2 to 3 women per week in Texas have major complications after an abortion procedure, and approximately 10 per week seek care in an ER. We heard testimony during the bill from physicians who have treated women in the ER post-abortion. Now, they won't have to lose precious moments while staff try to navigate hallways that are too narrow for a gurney or try to decide where to go or what to do next. That was the intent of the law we drafted and passed in the Texas legislature. It's important to note that multiple abortion providers in Texas already operated as ASCs, including Planned Parenthood, which operates 5 clinics. In fact, Planned Parenthood isn't even a part of this lawsuit. Federal Medicaid law has long required ambulatory surgical centers to either have a written transfer agreement with hospitals or ensure that all physicians performing surgery have admitting privileges at a local hospital. Again, this is to make sure that patients have immediate access to emergency treatment in a hospital should the need arise. In 2013, the Texas legislature responded to the chilling and gruesome national story that cried out for action. The steps we took were common sense and entirely consistent with standards for other medical facilities. HB 2 is clearly about protecting the health and safety of Texas women, period. It's for that reason that 121 legislators have added their names to the legislative amicus brief, which was drafted by former Texas Supreme Court Justice Craig Enoch. And again, I'm proud to be a participant in legislation that will indeed protect the healthy and safety of women. Thank you.
Next, you're going to hear from Jen Brown. She is the producer of the award-winning documentary film 3801 Lancaster, American Tragedy. Jen Brown.
Good morning. My name is Jen Brown. I live in Texas, and I'm the producer of the documentary film 3801 Lancaster, American Tragedy, a film about the crimes against women and babies that took place in Kermit Gosnell's abortion clinic in Pennsylvania. Working on 3801 Lancaster, American Tragedy over the last 5 years was an unbelievable privilege. Spending time with Gosnell's former patients and those in the film who identify as pro-choice made it clear to me that most Americans, regardless of whether they are pro-life or pro-choice, believe that common sense abortion clinic regulations are critical for protecting women. The Gosnell case has illustrated for our country, in an unforgettable way, the horror of what happens when abortion is allowed to go unregulated. Texans must lead the nation in saying, we will not let this happen again on our watch. Gosnell's case and the stories told in this documentary reveal what can happen when health and safety laws like HB 2 do not exist or are not enforced. As a Texas woman, I am proud to stand here alongside other Texas women in support of the common sense health and safety regulations required by law under HB 2. Laws like HB 2 affect real people. I spoke to many women who the state of Pennsylvania failed to protect. These women have emotional and physical scars that they will carry forever. Because laws like HB 2 were left unenforced, Gosnell made millions preying on women in desperate situations. It is for these women and the thousands whose stories remain untold that I support HB 2. I sincerely hope that all 9 justices of the U.S. Supreme Court watch the film 3801 Lancaster, American Tragedy and examine this case and uphold HB 2 to ensure that what happened in Kermit Gosnell's clinic never happens to a Texas woman or a Texas child. The women and children of Texas deserve better. Thank you.
Next, we're going to have Ann Hettinger from Concerned Women of America for Texas.
Good morning. This brief was submitted to the U.S. Supreme Court yesterday in support of HB 2 and was filed in conjunction with the Susan B. Anthony List, an organization of like-minded women who speak up for life. Though the critics of HB 2 claim to speak on behalf of women, CWA and thousands of women we represent have submitted this brief to let the justices know that this is a bill that thousands of women actually been fighting to enact for a long time, and it is to our benefit. HB 2, therefore, does not represent any type of sex discrimination then. Our brief shows HB 2 actually prevents discrimination against women. This legislation ensures the women who go to an abortion clinic are afforded at least the same level of quality care as men and women get when they visit other ambulatory care centers. It is simple and fair. By focusing on women's health and safety, the state looks out for the public's health and safety. This is a praiseworthy endeavor that would otherwise be applauded, aside from the blindness and the radicalism of the abortion lobby. HB 2 is not an anti-abortion bill. It is a women's safety bill. Texas went to great lengths considering the extensive testimony and other evidence when crafting HB 2. CWA's brief argues that careful consideration and the noble goal for the public health and safety of women in particular, but of all Texans ultimately, is more than sufficient to satisfy any level of scrutiny the court wishes to consider. I think women on both sides of this issue can agree women's health is more than a compelling interest. Texas acted in good faith to advance that interest when it enacted HB 2, and that is why it is clearly constitutional. We hope the Supreme Court resists the temptation to substitute its policy judgment for that of Texas, imposing its arbitrary preferences under cover of law. Thank you.
Yeah. Next, we're going to have Cindy Asmussen from Southern Baptist of Texas Convention.
The Southern Baptist of Texas Convention, along with the U.S. Conference of Catholic Bishops, Texas Catholic Conference, the National Association of Evangelicals, the Lutheran Church Missouri Synod, and the Ethics Religious Liberty Commission, have submitted an amicus brief to the U.S. Supreme Court in regard to HB 2. We affirm that women who undergo a medical procedure, including abortion, should receive a consistently high level of care ensured by state regulation. The SBTC is a fellowship of over 2,500 churches in Texas with more than 1 million members, and we support the well-being of all people who we have done so through resolution, benevolence, the conduct of family ministries, and the support of legislation, the belief that human life is sacred. Not only are human beings killed in an abortion, but the women who undergo an abortion are often traumatized, and in many cases they die. It is well documented that there are risks and complications of medical and surgical abortions, such as hemorrhaging, serious infections, cervical injuries, and perforated uteruses, organ failure, and many more, including death. Throughout the years, thousands upon thousands of women have submitted affidavits testifying to traumatic experiences and horrifying conditions. The state of Texas has a legitimate and constitutional right to protect women. Federal courts of appeals and medical experts agree that hospital admitting privileges are crucial to ensure physician competency, continuity of care, and support doctors' ethical duties not to abandon their patients. They also recognize that ambulatory surgical centers protect the health and safety of women by such basic requirements like proper sterilization procedures, EKG equipment readiness, and current life support training for staff. Nearly 1 in 4 pregnancies ends in abortion, and our churches deal with the broken lives that are devastated by it. Our Lord and Savior Jesus Christ is the only one who can heal the brokenness of our lives, and we are not without hope, but recovery is a difficult process. We help women suffering from post-abortive stress syndrome. They experience grief and feelings of loss that can lead to psychological disorders such as anxiety and depression. And there have been numerous studies, including the various ministries that we have at our churches, that have shown that abortion is significantly linked to changes in behavior, such as alcohol and drug abuse, eating disorders, and suicidal tendencies. We believe that HB 2 is a responsible exercise of the state's authority to protect the lives and health of women. The state has a legitimate interest in ensuring the maximum level of safety for the women subject to the abortion procedures, and that there is a viable plan for emergency care should complications occur. Civil government has no higher duty than to protect human life.
Next, we have Kathy Adams from Texas Eagle Forum.
Thank you. And I have to say that I am so grateful to have a governor, Greg Abbott, today, who stands with us, and also a former governor, Rick Perry, who, when a session passed nothing on our side of life, decided to call a special session, and not just one, but two. And he said, we are going to stand for life in the state of Texas. I'm so grateful then that Representative Laubenberg and now our comptroller, Glenn Hager, stood forth and said, here am I. I'm going to stand for life. House Bill 2 protects mothers' health. That's what this is all about. It limits the performance of a medication abortion, the abortion pill. It also requires abortionists to have admitting privileges within 30 miles of an abortuary, and it requires facilities to have the standards of an ambulatory surgical center, something that even federal law requires of its own clinics. So this is not something out of step. This is something that we have got to see as Andy Schlafly, Eagle Forum's founder's son, as well as General Counsel for the American Association of Physicians and Surgeons, makes very clear. There is no constitutional right to a back alley, less safe abortion. That's what we're talking about here today. Either you're going to have safety as you have with every other medical procedure, or you are going to have a politically correct, unsafe, back alley abortion. And that is wrong. This is why Governor Perry courageously stepped forward. This is why these legislators courageously stepped forward and overwhelmingly passed House Bill 2. Let us require good policies in the state of Texas and across the nation, requiring these doctors, these abortionists, to have admitting privileges at local hospitals, and to require abortion facilities to have structural requirements applicable to ambulatory surgical centers.
Next, we have John Seago from Texas Right to Life.
All right. Well, I think you've heard everything you need, but so I'll be quick here. My name is John Seago. I serve as the legislative director for Texas Right to Life. We're a pro-life organization that seeks to protect innocent human life from fertilization until natural death. Texas Right to Life was proud to work closely with Representative Laubenberg and Senator Hager and all the groups that are represented here in passing House Bill 2 back in 2013. And we're honored again to continue this fight to make sure that this law is fully enforced, because the legislative intent that Representative Laubenberg had, that Senator Hager had, and that these groups had in working on this is still a need in Texas. Women need these common sense protections, and it is amazing that the abortion industry is fighting tooth and nail so that they don't match common sense medical standards that we see that more than 500 other clinics that do other procedures in Texas have to follow. It is unthinkable that this would be such a controversy. Texas Right to Life filed a brief yesterday in the Supreme Court with Texas Eagle Forum in support of House Bill 2. This is a historical moment for the pro-life movement. Not only has the Supreme Court avoided the topic of abortion for 8 years, but how the court handles our House Bill 2 will actually set out a roadmap for the rest of the country. Will actually set out a roadmap for other states as far as what safety standards they can pass, what laws they can pass and enforce in their states that will protect women seeking elective abortions. This court is looking at what constitutes an undue burden, whether House Bill 2 is an undue burden on a woman's access to an abortion. This test has been vague and it's undefined that the Supreme Court has used, and it is actually thrown against every pro-life law passed in the United States, whether it's an informed consent law, giving information to women before an abortion, whether it's abortion prohibiting specific elective abortions, or whether it's higher safety standards. the abortion industry uses this term, this undefined term, to attack our laws, and hopefully the Supreme Court in this case will clarify what an undue burden is and reinstate a state's interest to protect their own women from the dangers of elective abortion. The reality is that the entire abortion industry has not challenged this provision. Some abortion clinics, it has already been mentioned, some abortion clinics in Texas are already following these standards. They're not outside of reach, and they are complying with the law. If the court rules, if the Supreme Court ends up ruling against House Bill 2, they will be establishing a slacker's veto. That whenever the abortion industry simply has to, all the abortion industry would have to do is simply threaten to close their doors, and that would make a pro-life law, any kind of safety standards, unconstitutional. This is obviously ridiculous. This is obviously something the Supreme Court should uphold, and Texas Right to Life is proud to stand with these groups here, to stand with Senator Hager and Representative Laubenberg in seeing this law through. So at the end of the day, we will enforce these standards, and we will protect Texas women seeking elective abortions. Thank you.
And last, we have Stephen Casey from Texas Center for Defense of Life.
Good morning and thank you. Texas Center for Defense of Life filed an amicus brief at the Supreme Court on behalf of And Then There Were None. Texas Center for Defense of Life aggressively defends life in federal and state courts. And Then There Were None is a 501c3 nonprofit organization that aids abortion workers from getting out of the abortion industry. They have a unique position here because they actually worked in the clinics. They can see the low safety standards that are going on, and they can specifically and personally identify with the abuses in the low safety standards they observed. You've heard many times about how these are reasonable and rational ideas to promote women's safety. But I want to speak about our brief, had a slightly different angle. In addition to saying that, it pulled back the curtain a little bit and revealed that this is about money. See, the petitioner in this case, Whole Women's Health and some other physicians, they complain about their increased costs to provide abortion, not about access to abortion by itself, because there are over 450 ASCs in Texas. You could probably not throw a rock without being within a mile of one. So what's their complaint? Their complaint is a marketplace complaint. They want the Supreme Court to pick a winner and a loser. They don't want to lose money because they're a business. And going all the way back to Adam Smith, it doesn't take people in the marketplace very long to figure out they can complain and get the government to quiet down their competition. Notably, Planned Parenthood isn't the plaintiff here. Why? Because they have ASCs. They can meet the standards. Whole Women's Health is making an economic plea to the court for a subsidy. The court is not in the business of doing that. Their complaint is about staying in business. It's not about access to high levels of women's health care. In any product, any consumer situation, I don't know a single person that would go in and buy a car and say, give me the worst car with the worst safety record and no tires. And that's what Whole Women's Health is asking for. And the court should rightfully reject that plea for a subsidy.
Thank you, Stephen. In conclusion, the brief filed by Texas Values and 3801 Lancaster Film Project states that the Gosnell case is overwhelming proof that HB 2 requirements for common safe safety standards are critically necessary for women. The film 3801 Lancaster is an eye-opening experience for viewers to see the dangers of not having basic health and safety standards for abortion clinics. We urge the Supreme Court to look at the outstanding evidence that shows HB 2 should be upheld. We encourage every Texan and every American to watch this film, 3801 Lancaster, An American Tragedy, and we anticipate the day when atrocities like the Gosnell's Clinic will never happen again. The brief submitted by Texas Values and 3801 Lancaster Film Project also has within it an appendix that's over 100 pages long. That is the grand jury report from the Gosnell trial. That includes disturbing and gripping but necessary information that should be enough for the U.S. Supreme Court to know that this should never happen again. And the way that the information and the crimes against women and children can be prevented that are talked about in the grand jury report is for the U.S. Supreme Court to uphold HB 2. We also want to say thank you to the over 34 briefs. We want to say thank you to all the people that were a part of the over 34 different legal amicus briefs that were filed in support of HB 2. Those include a brief by our current governor, Greg Abbott, who was the Attorney General at the time when this case was making its way up to the U.S. Supreme Court. We also want to thank the fantastic work by our current Attorney General, Ken Paxton, as well as a brief filed by U.S. Senator Ted Cruz and U.S. Senator John Cornyn, both from Texas, that was joined by hundreds of different legislators at the federal level in support of HB 2. In addition to that, some other briefs were filed by University Faculty for Life, Texas Alliance for Life, National Association of Catholic Nurses, USA, the state of Wisconsin. The brief that was filed actually by Governor Abbott, we're thankful for that, and the 9 other states that joined that brief in support of Texas's HB 2 law. In addition to those briefs, the Ethics and Religious Commission of the Southern Baptist Convention filed a brief, the Association of Evangelicals, American Center for Law and Justice, the Texas Conservative Coalition, and many more. The arguments for the HB 2 case will be at the Supreme Court on March 2nd. And as I indicated before, that is Texas Independence Day. Texas Values will be at the U.S. Supreme Court for those oral arguments, while as I'm sure a number of other people from Texas will as well.